Hello, everybody. It is Arty of Arty's Corporate Fiction. Welcome, everybody. It is time. We are here to finish up the last of the Elite Eight, and then we are moving on to the Final Four, with the championship being held tomorrow. So, with this, we are going to start the last one with the number 1 seed, Judge Simpson, versus the number 8 seed, Judge Boyd. The favorite is certainly Judge Simpson, but I feel like there's a lot of people who are big fans of Judge Boyd. So I don't think this is going to be as lopsided as many people will think, but it should be interesting to watch. So you got Serrano right there. My Eek is doing his own thing. I got some water because I have work tomorrow. And welcome, everybody. I actually, on a side note, like I elected to get a replacement keyboard and a replacement mouse. These, they're still working. Don't get me wrong; they're still working. They're functional, but they are getting rough around the ears, and I need something different. And I'm going back to, instead of the clicky stuff that you can hear. I assume you guys can hear this. Can you hear this? I'm going away from that. Oh, you can't? Well, then my noise suppression is working at least. That's what I'm just telling you, Lane. That's what I'm saying. Anyway, well, that's the other thing too. I can't tell. The left shift is now a blob. D is now a blob. S is almost a blob. So yeah. Meanwhile, my mouse is getting nasty. I'm just gonna leave it at that. I actually tried cleaning it, and I think I ruined one of the buttons. So that's where we're at. But the new keyboard's coming in tomorrow. We're going back to the classics instead of the clicky. We're going back to the Thok of the 90s, of the 80s, classics. All right, let's get the show on the road. All right, we're gonna go through a 13-minute video of Judge Simpson, and then we're gonna go through another video of Judge Boyd. And we're gonna start here. Let me make sure. Oh no! I almost missed. I almost made a mistake. I forgot to switch up the commands. Let me do that right now. Change that to 8. And that to 1. There we go. And we are going to start. Foster, that's exactly the type I got. Foster is a Hall effect. Also, wireless. Oh yeah, that's the other thing too. I'm so done with wires. I can't take it anymore. So, both the mouse and keyboard are wireless. I need to escape from the wires. That's the other thing too. So yeah. I hate wires. I hate them. I need more space here. So I'm getting a Hall effect wireless keyboard coming in. Keychron is the brand name of the keyboard. Where's the overlay? All right. We're going to start in 3, 2, 1, go.
Don't talk to him. Court calls the case People versus Thomas Styron.
I'm Styron, the living man. I'm here by special appearance to address this matter.
I'm sorry?
So I'm Thomas Styron, the living man, not Thomas Ulrich Styron, the entity you know me as, or as I'm in the papers. I'm here to address the matter.
All right, thank you. You wish to be represented by an attorney, sir?
No, I'm here to address the appropriate persona.
All right. I do have to advise, so you're going to represent, you need to stand in the middle of the podium where he's telling you to stand. Now. Mr. Allen. If you don't want to cooperate and handle things, he wanted you in the middle of the podium where you're supposed to be. If you don't want to be there, then say no. I'm telling you now to do it.
If you want me to stand close to the mic, no problem.
Sir, you want to play a game with me? No. Not today. Mr. Allen, take him. We'll bring him back out when he wants to cooperate.
I forgot how quick this one was.
Yeah, I need an interpreter for the last two and that one.
May I swear the interpreter?
Yes. Is it for the last two cases?
Yes.
Yeah, that one we'll swear in.
Your interpreter, you're in front of the Honorable J. Cedric Simpson out of the 14th District Court of Washington County, State of Michigan. Our number is 1.
Get somebody from security to check back there.
She's got a shirt on. So I'll take it up makeup, so I'll deal with him. I'll take the cuffs off. Get it out.
I don't know that we're going to be doing all that, but let me ask you something. On the Styron matter, I sent my bailiff back to get him to bring him back out. The court is of the understanding that defendant, number one, is being, I will say, uncooperative, has purposely done some things to make it difficult to bring him out. What I'm going to do at this point in time, we're not going to wait and not going to play his game. We will hear him next week because of his behavior today before the court. At this point, I will revoke his bond and I will adjourn the probable cause conference. He certainly poses a risk to even bring him out. So I will adjourn this out to May 2nd, 2024, 9 a.m. or as the invite indicates. I will leave it there for the reasons that I've stated on the record. Mr. Mansour, he is not represented by counsel. If you would, for the court, take the opportunity to go back and to apprise him that of what the court has done and that I will see him next week. The court feeling that he's being uncooperative and not compliant. All right. Thank you.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Tariq Day.
Oh God.
Tariq Samaritari Day.
Oh boy.
The executor of the Tariq Samaritari Day Living Trust and the registered owner of the Tariq Samaritari Day Ex Relatione Kingdom Wilson Estate.
What?
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend.
I comprehend.
Oh, this guy. Nope. Nope, he's
The
not
court
having
has
that.
to further advise you that if you wish to be represented by counsel, the court will ensure that counsel would be appointed to represent you in this matter and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter, in that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not.
Oh,
What is it about that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything.
no. Oh, nope. Nope. No. No. No.
About your religion. It is irrelevant to me. I am indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role.
How
religion does not play a role.
religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir? Well,
according to the American Declaration on the Rights of Indigenous Peoples, as well as the international
American Declaration, no. Number one, he's trying to cite the Universal Declaration of the Rights of Indigenous Peoples. Number two, it's non-binding on anything and anyone. And number three, the U.S. never even signed on to it in the first place. So yeah, no.
or the United Nations Declaration on the Rights of Indigenous Peoples.
Oh, he corrected himself.
The state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
I am an Indigenous person.
No,
so
sir, what you're about to state is incorrect.
Well,
if you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
Well, that's a matter of perspective, sir.
Perspective,
It is, and the only perspective that's going to matter on that is mine.
Is mine.
We are not on indigenous lands, subject to indigenous or tribal rules. You are subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I overstand.
I do not.
There you go.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume that there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution, as well as the court and the officers agree to take a competency.
That's not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing in this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
yes, sir.
Are you going to cooperate and attend that interview?
Under threat, duress, and coercion, yes.
Pardon?
Under threat, duress, and coercion, yes.
No. It's not how it works.
I don't.
I'm asking you, are you voluntarily going to cooperate?
I say yes.
Pardon?
I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse
Are
me?
going to
I'll take the
cooperate.
interview.
But I think that's
Anything from the people?
the best he's gonna get.
Ask the people to prepare the order for the competency.
Yes, please prepare the order for the competency if you would, sir.
And the address for,
The defendant,
I see on the complaint is 14.
is that your address, sir?
Excuse me. That's correct.
All right. All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry. Can I get that date again, please, sir? I can put it in my calendar.
July 25th, you were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did. I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it. I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before today?
Well, as I stated at the last hearing,
No, don't go through what you stated at the last hearing.
well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. Young man, you're gonna figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
Is that it for me?
I just realized he's got the gold fringe. My bad. Classic. All right, Judge Boyd. Oh, sorry. Judge Boyd.
More.
Hello. So, counsel, have you received all discovery?
Judge, I have. I'm here because Ms. Mendoza requested that I withdraw. And in the past, I had always brought those to the court's attention. I generally see the court reject it. But recently, the new thing that is done over at the jail is they request you withdraw. Then they file a bar complaint against you. And then 20 hours later, as a lawyer, they reject the bar complaint. They end up getting another lawyer who doesn't do any better. And you've spent 20 hours of your time. I've done this 2 to 3 times in the last.
Oh, no, here's the thing. Ms. Mendoza?
Mm-hmm.
Hi, how old are you?
I'm 31.
All right. So if you want an attorney, then you need to, if you want a different attorney, you need to hire an attorney. Do you understand?
Okay, I understand, but he's basically telling me like these classes don't.
No. Here's the thing. Let me explain something to you. And this is me talking to you as somebody who's been a defense attorney, somebody who's been a prosecutor. Sometimes I would have clients who would think that what they're telling me would help their case. And it wouldn't. It had nothing to do with the price of peaches. But it's always nice for clients to take classes while they're in custody to try to get their life in order so that maybe if an agreement is worked out, that's something that can be presented to the judge. In this court, this is the process. I make sure that the defense has all of the discovery. What does that mean, discovery? It means that he's been given everything that the state has about your case so that he can properly prepare for your case. Then I require that the state make an offer to the defense, and then the defense is ethically obligated to present that offer to you, and then you can either reject it or accept it. If you accept it, then there will be a plea agreement. I will accept the plea. If you reject it and you all are not able to come to an agreement, then it will be set for trial. Here's the problem that I see a lot with people who are charged with cases. They think that attorneys, all we do is talk. They don't think there's anything behind that. But guess what? Every attorney that you see in here, one at least has an undergraduate degree. Then they had to go to law school. And when you see attorneys talking, there's knowledge about the legal world,
most of the time,
experience based upon their life and based upon what they have done. So just like you wouldn't go to a doctor if you needed a heart surgery, I guarantee you wouldn't be telling that doctor. And I know you're not listening to me, but I don't believe you would be telling that doctor how to do a heart surgery. I don't think you'd be handing to that doctor and saying, hey, let me show you this paperwork where I went to go to listen to somebody speak about something. And you wouldn't expect that heart surgeon to say, you know what, you're right. This is how I'm going to do that surgery. But for some people, some reason, people feel the legal profession, just anybody can do it. And you know what? If anybody could be in the legal profession, then we wouldn't have law schools, and then anybody could have their bar card and anybody could do what attorneys do. So what I'm telling you is, this is not Burger King. If you want your own attorney, that's the way to get Burger King service. The way you want it, you go out and hire an attorney. And I guarantee you, when you hire that attorney, he or she will tell you there are a few things that as a defendant, you have a choice over. You have a choice. Am I going to testify at trial or not? Am I going to accept a plea bargain or not? Those are some of your choices. But trial strategy, that's not within your purview. That's solely within the defense attorney's purview. So this attorney is willing to speak to you. This is the attorney who's been appointed to represent you. But what I can tell you is this train is going to keep moving. You understand? Yeah. So all discovery has been received. State, were you able to tender an offer? Were you able to talk to your attorney about the offer that was tendered?
Yes, we talked about it.
Do you need more time to talk to him about the offer?
Oh, yeah.
All right. So if y'all will sit in the box and he will talk to you, then you can reapproach counsel.
Sure. Thank you.
15 minutes later.
Who's here on Frederico Ojeda, State of Texas versus Samantha Mendoza? Can I have parties announced for the record for the state? Defense?
Eddie Bravinek.
Are you Samantha Mendoza?
Yes, Your Honor.
no.
Counsel, have you received all of the discovery?
I have your.
Ms. Mendoza, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're waiving the enhancement paragraph.
Any objection?
No, Your Honor.
Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with the offense of possession of a controlled substance?
Yes.
Felony group 1, 4 to 200 grams. That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea, and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe
I thought
she has
this was
a
gonna be a
rational
better
as well
one.
as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Mendoza, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
So, what's your mother-in-law's name?
Angie, I already don't know too much. My girl's right there. She could tell you about her mother.
Oh, let's bring her up.
Oh boy.
Sir.
Angie?
Testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. Keep your voice up so the court reporter can hear. All right, can you state your name for the record?
Gabriela Montes.
Gabriela Montes. So are you and Mr. Elizondo married?
Not by law. Okay. Maybe like 2 years. Oh, it was in 2020. We worked in the same company. So 20 years.
So you worked in the same company in 2020? So why did he no longer work there?
I really
At
don't.
that time, I was having issues with myself.
I really don't remember, but I mean, he does like side jobs, I guess you could say, here and there.
Okay. All right. Thank you so much for giving me some insight. All right, he can come back.
Judge, I believe basically in just the evaluation that Dr. Smith made, I think there's probably the court can become cognizant of the fact that why he's unable to be employed. He kind of, with his bipolar situation, it's just kind of difficult for him to be able to probably hold jobs.
All right. This is what the court is going to do. There's to be no contact with 210. Sorry. It is. There's to be no contact with 210 Sports Bar located at 1946 Southwest Military Drive, San Antonio, Texas, 78221. There's going to be a mental health evaluation
San Antonio.
and a
I've been there
TAP
a
evaluation
long
in
time.
custody. There's to be no unsupervised contact with minors. 6
Jesus.
years deferred adjudication. Follow all TAP recommendations. There's going to be a $2,000 fine. The court will probate the fine.
Thank you, Judge.
This is run concurrent with 717-866. Take in consideration 718-308, 720-320, 720-321. There's to be restitution, if any, to the city of San Antonio and cause number 720-320. There's going to be 200 hours of community service restitution. I'm going to order parenting classes once parenting class.
Wait a minute. Man, I feel like I'm missing so many good ones. I know Judge Boyd has a lot of really good ones out there. I'm not doing her justice.
Noon, Your Honor.
Afternoon. So here's the thing. Don't send a message to the court with profanity in it. Number one, your case is set on the day it's set. The person who you need to perhaps send that to is the person who is not here.
Correct.
Do you unfold your arms? So don't do that. One, you need to speak to your attorney, and your attorney needs to be here. This case has been set numerous times waiting for your attorney. So the fact that you have what you put in your letter, I have bills to pay, I'm not a scrub.
Correct.
I have my own house and car now and have to pay the bills.
That's correct.
That's who you need to be sending that to your attorney.
Which
Not-
So she sent. Wait, she sent that. So he sent that to her, the judge.
I have,
All right.
which I have.
And there's nothing I can do with that.
And then you sending me here every day, every day.
How dare
How am I
you.
going to pay bills? You say this is a place of communication.
Well, here's the communication. You need to talk to your attorney because guess what? The court schedule doesn't revolve around your attorney.
You.
It doesn't revolve around you.
And not
This
to be rude or
case-
anything, but
here's the
he doesn't
difference.
revolve around you
This
either.
case-
He has stuff to do. He has federal inmates out of
Yeah.
county.
All
I
right,
can't
so-
make him. I tried.
All
I
right,
tried.
so this is what we're gonna do. Oh, we're gonna wait for his attorney. Okay, thank you.
May I be excused or?
Yeah, we're waiting for your attorney.
Okay. He's not going to show up till the 3rd.
No, I'm sending an email to his people, his office to let him know he needs to be here.
I believe he's in Guadalupe County today and another county. I don't know which county.
In alphabetical order, Bear comes before all of those counties.
Bexar. It's Bexar County. Idiot.
All right, are the parties ready on Gabriel Echartia? We're gonna find out how to pronounce that when you all come up, at least how I can pronounce it.
I'll let him explain that.
How do you pronounce it?
Echartia.
Echartia, okay, Echartia. All right, court is calling 2024 CR 1497, State of Texas versus Gabriel Echartia. Could I have parties announced for the record for the state?
Jason Garahan, Your Honor.
Defense?
Brian Kimbrough.
And are you Mr. Echartia?
Yes, ma'am.
Counsel, have you received all the discovery that you review with your client?
I did.
Mr. Echartia, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Stand under.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
I did.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Mr. Echartia, did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with the offense of evading arrest detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to
Eric
follow
Scott,
your
thank you for
plea.
the
If for any
42
reason
months,
the
man.
court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
No.
No. Did you understand what your rights are?
Yes.
And are you intending to give up those rights to enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, sir.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I did.
Do you believe he's currently competent and was legally sane at the time of the offense?
I did.
Mr. Echartia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Trial motions that have been filed, waiving consent to...
What? Oh, that's the channel that did that.
All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred
Semi-active with the 46
adjudication.
months.
Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
I would ask the court to follow the plea bargain. Mr. Ortea has no criminal record. He's what, 20? 20 years old, Your Honor. This was a big mistake. He understands that, and he'll do well on probation, I'm sure.
I'm sure of it.
All right. So why are you going 100 miles per hour?
Yes, Your Honor, that day I was going to school.
All right. So here's the thing, and your attorney will tell you this. When people start a sentence with, to be honest with you, usually what's coming after that is not honest.
It's
And then when people say, in all honesty, what's coming is not honesty. Whenever you hear people talking and they say, well, with all due respect, what's about to come,
or it's like, I'm not gonna lie,
is without respect. So you're speeding, going 100 miles per hour. Why?
I was going to school.
Yeah, but why are you going 100 miles per hour? Other people go to school. They're not going 100 miles per hour.
You were late.
I'm sorry, what?
I was running late.
So you're running late. And what school were you going to?
I was going to Pathways Home Education.
And whose car were you in?
In my vehicle.
All right. Do you have insurance on that vehicle in your name?
Yes.
And were you paying for that vehicle and paying for the insurance?
Not the insurance, Your Honor.
Who was paying for the insurance?
Be my mother.
And so how long were you in doing home education with Pathways?
About 3 months.
And where were you doing education before Pathways?
It was Stevens High School.
All right. So why were you at Pathways Home as opposed to Stevens?
I had dropped out at Stevens High School during the pandemic because they weren't counting me present in my classes anymore.
So congratulations to Judge Simpson. Again, I'm not entirely shocked that he would move on to the Final Four. And with that understanding, we're going to set up the first match of the Final Four. And let us go with we're going to go with Judge Oakley versus Judge McNally, or Judge Dad. I know. I apologize. I really thought I was able to find some good ones for her.
Mm-hmm.
And I wanted to go back to school. So we had found an educational program for students that wanted to work from home, or if they wanted to, could go to the school physically if they felt comfortable with it.
Mm-hmm.
And I was just running like that day. And I'm trying to go back to school now. Really.
So have you graduated?
No.
So
when
how
I
do you
went into jail? That kind of made everything fall apart.
And then I bet when you went to jail, that sort of woke you up too.
Yes, ma'am.
Mm-hmm.
So how far did you go in school?
How far? About junior year.
So you're in your junior year, you're 20. School is different from when I went.
At that time,
it was rare that 18-year-olds were still in high school. They had already graduated. So I'm trying to figure out why at 20.
First grade.
I'm sorry?
I got held back in first grade.
Okay.
But I was 19 at the time, so I was still eligible for a high school diploma. So that's why I was going through that education program to get my diploma.
All right. How long have you been out of custody?
Custody, I believe. To be honest with you, I don't remember.
You don't remember?
Damn it. I'm sorry. I can't do this to her. Where's it? OSG. Oh, this guy.
All right, court is calling 2024 CR 4260
This kid wouldn't
and
shut the hell up.
2022 CR 4259W, State of Texas versus Renee Angel Cantu. Can I have parties announced for the record for the state?
Daniel Escobar with the state of Texas.
Defense?
Floyd Barrera, Jr.
All right, and are you Mr. Cantu?
One of your honor, yes, ma'am.
All right, you entered a plea on April 2nd of no contest in each of these cases. The court found there was sufficient evidence to find you guilty in each of the cause numbers. All right, and each of the cause numbers, according to the plea bargain agreement, the state is opposed to your application. And it states in here that this is running concurrent with CM 105821.
And I think, Judge, that's one.
And they're taking in consideration CM 104043, NIMAG number 712122 and 712121. All right, state, you are opposed?
Yes, sir.
All right, any witnesses from either side?
Just my client, Judge.
All right, if you can raise your right hand for me, please. Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am, your honor.
All right, you can lower your hand, state your name for the record.
Rene Cantu.
All right, defense, you may
Good morning.
proceed with direct examination.
Thank you, Judge. Good morning, Mr. Cantu. How old are you, sir? I am 33 years old.
Okay. And are you currently on probation in this court?
Yes, I am.
All right, and what are you on probation for?
I am on probation for a possession of manufactured delivered 4 to 200 grams that happened, I believe, in 2021.
Okay. Now,
Okay.
when you applied for probation in that case, which the court just ordered up, all of the matters that you've taken care of with Mr. Neil Cordero, they were all pending and included in the PSI that the court placed you on probation for. Is that correct?
Yes, sir, that's correct.
Okay.
All in 2021.
But since that time, most of those cases, the majority of those cases have been disposed of, either taking them into consideration or just outright dismissed.
Correct.
And now you're before the court on two of the cases that were pending before we even applied for probation in the case that you're on probation
Oh,
for.
yes.
Is that correct?
Yes, sir, that's correct.
Now, is it true and correct that since the court has placed you on probation, no violations of your probation have ever been filed or have occurred?
That's correct, not one. And I've been on this monitor for 3 years and since then.
All right, so
good.
you're on a monitor for 3 years,
Jesus,
no
oh my
violations of the
God.
monitor. You've been drug tested for 3 years and no violations of any drug testing.
Is he tweaking?
Been, suffice it to say, 100% clean.
Correct.
And in 100% compliance and in obedience with the court's probation.
Correct. And I don't know if the court remembers, but they gave me like a list of 9 things to do.
Correct.
Like intensive outpatient treatment in 12 weeks, a 90-day program, like just 9
No,
separate things, but
the vote's over.
I've completed all of them. So yeah.
All right. And are you gainfully employed?
Yes, sir, I am.
Are you full-time employed?
All right, I give up. Someday, one day, I'll find something that's gonna do Judge Boyd justice. I've failed her, so I apologize. Judge Oakley versus Judge McNally. I mean, I don't know. This is gonna be interesting. Hold on a second. I'm missing some. I don't know. I don't want to retread the other videos that we've already seen for McNally and Oakley. Although the thing is with McNally, I think him ripping that sovereign citizen is what made him pretty famous. Man, I just like because the next matchup is going to be Judge Middleton versus Judge Simpson, and there's no shortage of great content from both of them. I wasn't expecting neither McNally nor Oakley to get to the Final Four. Ugh. Oh, we already saw that one. Uh-oh.
People against Anthony Eli Liberty, 23T720712.
Michael A. Cartman, P73824 on behalf of the defendant, Your Honor.
Okay. Mr. Liberty, your name?
Anthony Liberty, Your Honor.
Did you speak to him?
I did, Your Honor.
And what would you like?
He understands that he's forfeited the 769 status. He can live with that. Your Honor, the biggest thing is we were just asking that the court not...
well, let's cover that first. So he agrees and understands that the case will not be taken under 769 4A, correct?
Yes, sir.
Is that right, sir?
Yes, Your Honor.
So I want to be clear about something. I'm going to cover this with you. Just let me finish.
Okay, yes.
I'm going to cover this with you again. Initially, I took the plea under 769 4A, and I explained to you that the proceeding would be deferred. In other words, that I would essentially take the plea, not enter the conviction, place you on probation, set terms and conditions, and then if you complied at the end of the probationary term, the case would be dismissed. I just explained I'm no longer willing to do that based on the fact that you didn't show up here for about 14, 15 months. You had numerous bond violations. Your lawyer is telling me that you understand and agree that the case will not be taken under 769.4A now. That is, that you will be sentenced on this case now, and the conviction will enter now. Do you understand that?
Yes, Your Honor.
Do you agree to that?
Yes, Your Honor.
All right, so I don't see a need to take the plea again. I trust you agree, Mr. Cartman.
I would agree, Your Honor, for sure.
All right, so I'll just indicate parties agreed and understood the case will not be taken under 769.4A. Okay, with that, have you had a chance to review the report? Are there any material additions, corrections, and deletions?
Your Honor, yes, I have, and no, there are not. Just want the court to be aware that my client is currently prescribed medications for his mental health. He does a Vivitrol shot to combat, substance abuse cravings. Takes Wellbutrin and Effexor. So he's getting treatment for his mental health as well, Your Honor. And that would continue if he's to proceed to Oakdale, as is his plan. His mom is his legal guardian. He indicates to me that they've had a very good relationship since after this incident. Last year in January through May.
Have I ever thought of being a judge? Yeah, but there's no way in hell I'm doing that. This channel will not allow me to do it.
Was doing rehab at Oakdale, as well as had a stint in, I believe, the mental health ward of the hospital. And after he got out, his mother helped him to secure housing. So after he was out of rehab, so we do have a good relationship now. He wants to just proceed to rehab and just to get all the help he needs for substance abuse and just ensure none of this ever happens again. And
well, I want you to understand, and I hope I made this clear. My tendency is to simply set him up. Where am I hearing all that feedback? Boy, that's worse over there now. You know that? At any rate, my intention is to simply send him to the medical unit of the Wayne County Jail. and let him get mental health treatment. I believe that that's what he needs. So,
Your Honor, he disagrees, and
Please, Your Honor. Please, not that, Your Honor.
Mr. Liberty, will you stop interrupting? I didn't ask you anything yet. Do you want to say something else first, Mr. Carmen?
Your Honor, just thinking his mom is his legal guardian. It sounds like she is on board with him going to rehab, specifically at Oakdale. That's been their plan.
You read all these letters she sent a year ago, right?
I read the one from December 23.
Right.
Please, Judge.
Mr. Liberty, stop. He needs mental health treatment more than he needs substance abuse treatment, to be honest with you.
Mr. Liberty, if you went to Oakdale, what mental health treatment options would you have there?
So I'm already seeing a counselor 2 times a week via Zoom with Hygera, which is the same it's the same company that runs Oakdale. It's out of Lincoln Park. I have a doctor assigned to me. I'm taking medication. I'm attending all meetings. I'm taking the shot. I'm ready to get my life back on track. I'm ready to go to Oakdale because last time I had over 100. I had like 117 days clean. It's a very good environment. There's meetings for 12 hours a day. It's my mom. That's what my mom told me the other day on the phone. So, I mean, 2 days ago.
You still have those other cases pending, right?
What other cases, sir?
You still have the case. Slow down.
Okay.
Let me finish.
Okay.
You still have the assault resistant
Yes,
obstructing
Alpha, we have
officer
gambling back.
pending. And would you please stop interrupting me, sir? And you have the flee and elude 4th degree, right?
May I speak? So I just the obstructing, there's obstructing the arrest or whatever. That one's dropped. That one, they already dropped that. They dropped that last week. And then they're about to send me on, they for the fleeing and eluding, they're going to drop that to a misdemeanor. They just told me the other day, my attorney came here, and he said that I was going to be going to Oakdale on a tether in lieu of jail time for that. And like I mentioned, my mom, I just talked to her 2 days ago.
Stop. I don't want to hear about your mom right now. Do you have a plea agreement? When are you going back to court on that case?
March 5th.
Well, March 5th is 7 weeks away. They're not taking you over to Oakdale now.
They said that they want me to Oakdale. They said that they had me on a tether on Monday. They had me on a tether the same day that I saw you last week. They had me on a tether going to Oakdale. They had me in the tether department going to Oakdale, sir. They have a bed available. I just want to get my life on track. I just want to go back and get clean, sir.
You don't want to, I'm not so sure about that. You don't want to be in the Wayne County Jail.
I want to get clean, sir.
Mr. Liberty, if you wanted to get clean, you would have come in and seen me a year ago. If you wanted to get clean, you would have shown up for your tickets that you've had elsewhere. California, you got a drunk driving, you never showed up from 2022. Please don't tell me that. You don't want to be in jail? I get it. Nobody wants to be in jail for the most part. I haven't yet to have anybody come in here. Well, I shouldn't say that. Twice a year, I get somebody tell me they don't want to do probation, send me to jail. But overwhelmingly, the 99% do not want to go to jail. I feel like I need some more information on this. Let's call in Jessica a second, please. They're not taking you over to Oakdale before the plea. I can tell you that.
Excuse me, Your Honor. They told me that they want me in Oakdale on a tether, sir. They told me that. They were going to send me, they were on board with that last week on Monday, sir. They want me to, that's what the judge in Romulus said. That's what the judge in Romulus told me. Specifically, he said, I'm going to get you a bed, I'm going to get you a tether and send you directly to Oakdale from the jail. I'm not just trying to get out of jail, sir. Oakdale is what I need. Treatment is what I need. 100%. I need substance abuse treatment.
All right. Okay. Don't tell me what you need and don't need. You need a lot of things. Your name? So here's what I think I'm going to do. He's telling me, I'm not quite following it all. It sounds like something was reduced to a misdemeanor.
From when I looked online, he's scheduled for a pretrial exam on those new felony charges on February 5th. So that hasn't been addressed yet. There's still felonies.
He's saying,
There's scheduled for a prelim, I did check online.
You haven't had a preliminary exam yet, right, Mr. Liberty?
I don't know. I'm not sure. But I know this. I know this. They put me on a tether on Monday, this past Monday, right after we got out of court. Right after I got out of court with you. The judge agreed to send me to Oakdale on a tether.
All right, okay. I'm going to adjourn the sentencing
very
one week.
confused
Will you
about this.
call over to 34 and see what you can find?
Oh my God.
Listen, Mr. Liberty, just settle down. I need to find out what is going on here. January 21. I assure you, I'm not your enemy here. I'm trying to figure out what the best course of action is for you. Just relax.
My mom, listen, Your Honor, my mom sent a whole email to Jessica. She sent it 2 days ago. My mom wants me in rehab.
I'll tell you what, Mr. Liberty.
Whatever.
An email from.
So I got an email from his mother. It doesn't account for the whole time he's been missing, but she claims that from February 5th of 2024 to April 8th of 2024, he was in Stonecrest Mental Hospital downtown.
Right.
And then from April 8th to May 10th of 2024, he was at the Oakdale Rehabilitation Center in Canton.
From what date? The last one is.
The last one was April 8th to May 10th. So overall, it was from February 5th of 2024 to May 10th of 2024. He was in some kind of facility.
I mean, based on my layman observations, I mean, the guy does seem to. He's either on something or he does have, like, he's got something wrong in his head. Whether or not that has taken away most of his agency, I don't know. This is our first encounter with him.
I wasn't trying to avoid you, Your Honor.
All right. Okay.
I just want to get clean.
I have all these other letters here, and I feel like I want you to find out a little bit more. I don't know where I want to send him. I think he's got. I'm going to adjourn it 1 week until 8:45 on the 21st. I can assure you I will move on this then, Mr. Liberty. I want to make sure we're doing the right thing.
So you're going to put me in? Are you going to put me in rehab, or are you going to keep me here and put me in a mental ward where it's going to destroy my mind?
Oh my God!
You can't just let it go. You can't just let my mom. Those are old letters from last year. My mom and I have a great relationship right now.
You better.
She detailed everything in the letters to her 2 days ago.
Listen.
She wants me to go to rehab. You're gonna keep me in here for another week? I'm gonna lose my mind, dude. You know they're swatting. They swatted. 20 of them surround me, and they swatted cleaner in my eye the other day. I'm losing my mind here.
Settle down.
Oh boy.
Settle down.
It's fucking unbelievable, man.
You're unbelievable.
Mr. Liberty, stop talking.
Let me talk to you and Ms. O'Donnell for a second. Good chambers. Go off the record.
Uh-oh.
Mohammed, did you talk to Ms. Watt?
Man, this probably was not McNally's best moment.
None of that does anything. That's more of the bullshit that we just ignore that stuff. So you want a hearing? Well, if you want him to prove it, then you ask for a hearing. Yeah, what brand?
Oh, Terex.
Terex, all right. So basically the argument is your Terex is not a motor vehicle. Well, it's not an ORV, not an ORV. Okay. So I saw your response this morning. I saw your reply to her response. Did you see those, by the way, the reply? All right. So I think we've all seen the same paperwork. Okay. You want to hit some highlights of your arguments?
I mean, my argument is pretty much cover the whole thing, and like I said again, this goes back to just trying to label this an ORV. And a strict ORV, like if I took a monster truck up on the roadway that takes up both roadways, can't turn, make turns in the roadway, right? The way the statute's applied, they could be, and for instance, they advertise like Ford Raptors and such, right? They show them in all the commercials going up mountains, same Jeeps, all, they advertise, hey, take them all off road, right? So the way the statute's written, they can just basically be like, oh, hey, anything with that looks like, pretty much any vehicle is capable of going off road. So any given time, the way the statute's being applied to me, they can just, any vehicle is capable of being taken off road.
Let me stop you though. Let me stop you. That's actually a different argument. So one argument is your Terex is not an ORV. The other argument is their ordinance or the statute they're applying is just too vague. It's just unconstitutionally vague. Would you agree with me? That's two different arguments?
I think they tie together.
Well, absolutely. absolutely. But the reason I want to make sure we're all on the same page, because I think there's two different responses that could come and two different decisions that could be made. Would you agree with me? Okay, so I want to take them one at a time then. So first is, well, one would be your Terex is not an ORV, doesn't meet the definition. And the second argument would be, and the definition they're using is overly vague. Okay, so Madam Prosecutor, pick one of those arguments. Let's pick one and we'll talk about one at a time.
Certainly, Your Honor. Let's start with whether or not the utility.
Just call it Terex. Just call it let's make it specific to him, the Terex.
324-81122.
Oh, give me that again. I was somewhere else when you started talking. Go ahead. MCL.
81101 sub U defines ORV as a vehicle, a motor-driven off-road recreation vehicle capable of cross-country travel without benefit of a road or trail on or immediately over land, snow, ice, marsh, swampland, or other natural terrain. It goes on to give examples of what is included in an ORV and what are not included as an ORV. Here, the utility terrain vehicle, as Mr. Cruzell labels it, is an off-road vehicle. Exhibit A that I included in my motion is a.
Let me stop you. I'm sorry. In your reply to his motion, is that where your exhibit A is? Okay, go ahead.
Owner's manual of the parent. It particularly states under basic stage off-road vehicle, off-highway use only. This vehicle is not an all-terrain vehicle. It is designed and equipped to be a multi-use utility vehicle for off-highway use only. Use of this vehicle on public roads and paved surfaces is hazardous. Do not operate this vehicle on public roads or paved surfaces. In addition, in Exhibit B, I included a relevant portion of the ORV handbook that is found on the state of Michigan's website, and it includes utility terrain vehicles as an ORV. It also, conveniently enough, includes a photo of a near identical ORV that Mr. Cruzell operated back on February.
Wait, so she's describing, I guess, a website of Michigan's Department of Motor Vehicles saying these types of vehicles you cannot use on the public roadway, and then an example picture of what is not permitted is the exact type of vehicle that he was driving, that he was using on the road.
Where is third of the sticker?
Okay. Anything else?
I guess I can go further. Mr. Cruzell then goes on to liken it to something like a Ford Raptor, a Jeep, monster truck. The multi-purpose personal use vehicle used for personal family conveyance. MCL 324.8112 sub 1 states that an individual shall not operate an ORV that is not registered under the code upon a street, county road, or a highway. A Ford Raptor, Jeep, and a monster truck all need to be registered in order to operate on.
Right.
Mr. Cruzell was not pulled over because of his operating an ORV, but because that ORV was not registered, did not have a license plate. For that reason, I believe that this motion should be dismissed and the people renew their request for motion.
I have an objection to that, Your Honor.
Yeah. Well, it's not an objection, it's a response, but go ahead.
Okay, well, again, none of the registration or any of that stuff was even brought up. Any of it, they slapped an ORV on it because they had me held in the car for 45 minutes on the phones. I have a body cam trying to figure out what to even charge me with because I wasn't pulled over in retaliation. And that is what they pulled me over for. Rating going is what was stated and put on there. And going back to liability or the not operating on highway use, it's referring to, we purchased those, I don't know if that involved one or used them. They tell you that they don't They come stock to only go about 50-ish miles an hour. You can get a model to make them go highway speeds when they're referring to highway.
I saw that in your response.
The higher speeds, and that would be the reason why. And I think everyone does nowadays see how common these UTVs are, see them all over the place.
I got to shoot you down there though. Because you spend a lot of time talking about that you see these all over. That doesn't make them legal. I mean, that just bottom line doesn't make them legal. The fact that some, for example, some communities just kind of like turn a blind eye to golf carts, right? That's not necessarily saying they're legal. That's just saying they're not enforcing them. Now that gets to your other argument, which, you know, does that create an unfair situation? But that's, I gotta shut you down there, because just because you see them doesn't mean they're legal. But let's get back to that language you used. Like, I gotta find it. Oh, okay. Do not operate this vehicle on public roads or paved surfaces. I understand your argument is they're telling you to stay off the highway with a stock Terex, but they didn't say highway. They said not safe for public roads or paved surfaces. That's what they said.
What?
So I'm just.
Again, why? Just like how they put on bicycles, they wear all those knee pads and helmets, right? So
I understand that.
They don't operate on public roadways without a helmet.
I understand that's your take on what this means, but the clear language says don't go on paved surfaces.
Yes, clear language and same with the manuals for, again, dirt bikes, motorcycles, right? Yeah, that's still legal for people to drive around without helmets.
All right.
Because it's a liability issue. That's why they put it in there.
So
what people do with something after purchase it.
So my understanding is that if you jump through the hoops, if you go through the process, it's possible, you know, you might have to add some equipment to your Terex or whatever. But it's possible to get some of these vehicles registered as roadworthy with the Secretary of State.
Street legal.
That's my understanding. You know, if it's got, and I made a list, you know, if it's got bumpers at the correct.
Right. So that's probably why they're not permitted, is because they don't have some of the basics that you need on a vehicle: bumpers, turn signals, the like.
Type. It's got windshield and wipers and rear view mirrors. If it's got all this safety equipment, then you can get it registered and put it on the road legally. Is that your understanding?
Oh, no, in my defense, before this even happened, Sergeant Bryce, there was a bar there.
No. Hold on. I'm talking generally. I'm not talking specifically to you. I'm talking generally speaking. Do you agree with me that there is a process that the state of Michigan has that you can take something that may be an off-road vehicle and you can go through steps and have it roadworthy and registered as such with the state of Michigan? Do you understand? Do you agree there's a process for that?
I'm for certain vehicles, I would say, yes.
Okay, all right.
My specific UTV, they are already equipped and sold, road ready.
Okay.
Again, you go back to the disclaimer, just because they put it in there, it's a disclaimer for there.
Then why have you not registered as a vehicle with the state of Michigan?
Sergeant Bryce told me I was well within my lawful rights. I said that I stated numerous times, both to me and my wife at the gas station, right where I got pulled over. Well, previously to this, we even talked about it. We had a conversation about it at the gas station. The BP simply in Middleton. He instructed, even told me, you're well within your lawful rights.
Okay.
He said this numerous times. And then I relayed this to Officer, I don't know.
The officer that wrote the ticket.
Yeah, right. And then when I asked him the second interaction I had with him, I asked him, like, dude, I need to get you, which is part of the body cam. I'm still trying to get a hold of these things because I have to take them to court for it. Because they're withholding body cam image. Or where I asked him, hey, I need you to get a supervisor to clarify this. Because he told me I'm not getting a pissing match and drove away. So
all right, stop there. Hold on. Is it your understanding that there's a mechanism by which if the safety equipment is there, then the vehicle can be registered with the state of Michigan?
But it's my understanding that the specific township or municipality needs to adopt or identify certain roadways that they are then able to operate on. As far as I know, the township Huron doesn't have any that are safely permitted. I do believe that.
Hold on. You're telling me if the state of Michigan registers it as a motor vehicle, you guys can still say you can't go on your roads?
I believe it's county owned roads. Or it's my
even though the state says it's a motor vehicle? Because that's my understanding. If the state registers it as a motor vehicle, that's what they're doing after all the safety equipment is there.
But I believe it's for limited use. So there's examples in the statute that talks about for limited purposes of say like parades or something to that effect.
Again, Your Honor.
Hold on. I'm cogitating. Well, it would seem to me that the township's got to get off its ass and do something with their ordinances on register. I mean, if the state's out there authorizing people to drive these on pavement and you guys just haven't decided where they can and can't, it sounds like the township's got to get on the board.
You can look up their one that's decided, to be honest, they said it didn't exist.
What doesn't exist? I'm sorry.
They're trying to charge them with the code they gave, they said it doesn't even exist. I couldn't even look it up.
Brother, you keep throwing new arguments in.
No, I'm sorry. Well, I'm just bringing it up.
Hold on. Let's not get there yet. I'm making notes so you don't forget to get there, but don't get there yet.
I'm thunking.
I'm having trouble figuring out how the township can tell somebody they can't operate a motor vehicle that the state of Michigan says is a motor vehicle.
Your Honor, I am not specifically prepared to argue that only because Mr. Cruzel's ORV wasn't registered, so it has no bearing on whether or not it can operate.
Hey, welcome Raiders.
But it can be.
Souls.
Well, don't get me started with that.
Thank you, Colin, for the raid. You have time to vote in one of the final 4 matchups between Judge Oakley and Judge McNally.
All right, so let's talk about the fact that they've charged you under an ordinance that doesn't exist. My paraphrase of your argument.
Yeah, I've been trying to clarify too, and bring it up too, but I've been trying to find it, doesn't even, the code they cited doesn't even exist.
All right, hold on. Let me get to the paperwork.
I just had one fact I wanted to throw.
Hold on. Don't do that. You're confusing me. Make your notes so you don't forget. All right, so if we look at the ticket, offense code is 257311. Authorization code is, I don't know what that is, 00003.
Yeah, I think.
Is that, I'm reading it 00003. So I guess let's get a clarification from the prosecutor. What is a specific ordinance, statute, whatever, that the ORV on roadway is being prosecuted under?
So here on adopts the Michigan Defendant Code, which I referenced to, but I also stated in my motion that.
I'm sorry to interrupt, but the reply that I'm looking at for today.
Yeah.
All right.
We'll skip ahead here.
One body cam. Okay. All right. But you can't, off the top of your head, you can't give me that incident date.
No, that wasn't.
All right. So submit a formal request for body cam footage from that date to the prosecutor. She can check it out, see if it's been submitted to you prior. She can tell you when, she can resubmit it. She can file a motion with me and say, I'm not going to submit that because, and we'll go from there. All right. That's that one specific issue. Agreed? Okay. All right, let's get back to your argument, Mr. Cruzel, that the language that we just went over is overly broad or vague. Let's hit that again. So is it the definition of the ORV that you think is overly broad?
Oh, absolutely. It basically encompasses any, they said it even says, any vehicle capable of cross-country travel without benefit of the road, right? And that's any vehicle, I mean, you can even take a smart car off the road if you wanted to, essentially. I mean, and that's what I mean. I mean, the way you just read, they can just apply that anytime they want to any vehicle, whenever they want.
If I'm understanding your argument,
I tired her out.
I drive an F-150. right? So we would probably agree that
Maybe
we
not.
could take that off the road.
But
Do not.
in commercial, so that's what they.
Right, right. So your argument is because they could write ORV on a roadway for that means this statute or this ordinance is overly broad. All right. Except they can't because the state of Michigan has licensed me to put my F-150 on the road.
Mm-hmm.
But again, same question, mine can be the same thing.
But it's not licensed. It can be. It can be. And I would like to see you do that because then I want to see how they're going to keep you off the road. If the state of Michigan said you can put that on the road.
But
Right.
again, got it. The whole reason that they're trying to dance around the whole thing because they got it. They didn't bring up none of the registration.
I know you're getting back to the confusion
stuff, right? They're trying to use the definition of ORV to.
I get with the whole, you sat in the car 45 minutes, they decide what to do with you. I get all that. Okay. And that's problematic for me too. But I don't find this language to be overly broad because there's the licensing aspect of it that narrows it.
There's that conflict there, right? And that also shows the ambiguity, right? So you're saying that if I'm paying a tax stamp for something, then now all of a sudden it's not this, but then they're trying to claim it's this. So how does a tag all of a sudden make this, not this? Doesn't make sense.
Hold on, you lost me.
All of a sudden, so what they're trying to claim is an ORV, but if I magically go get a tax stamp put on it, right, registered, now it's automatically just motor vehicle. So now it falls under.
Yeah, but hold on. It's not just about the money. And believe me, brother, I'm the first one to think I'm the first one to jump in the bandwagon with you about the government grabbing money. All right. I fight that here. But it's more than that because let's just pick the specific example of an ORV. I could build myself a dune buggy, right? Completely manufactured. I couldn't because I'm not handy that way. But I mean, you know what I mean? I could get tubular stock and build a frame, and I could just grab a motor, an engine off of something else, and fabricate a drivetrain, and I could have something that I could take off, go through the trails and the hills. Would you agree with me? No, but I mean, I'm just like build it from scratch, right? I'm Henry Ford. I built it from scratch, and it's out there running around. But if I get it registered as a motor vehicle by the state of Michigan, they're putting their rubber stamp of approval on it, saying it's safe for me to put on their roads.
Mm-hmm.
There's a safety issue, not just a money grab. And that's the way I'm looking at this, because from my little bit of research,
and not shocking, Judge Oakley is the winner. Judge Oakley is going into the championship.
Roadworthy. I've got to have tail lights. I've got high and low beam headlights. I've got to have turn signal.
Now, okay. Here we go. I'm going to set it up.
Front and rear. I got to have a rear view mirror. The state of Michigan is checking all these things off before they license me or register me to put it on the road. And they're saying, they being the state of Michigan, saying it's safe to get on the road with the F-150s that you and I drive.
Yeah, but again, you're giving an example of someone building something. The thing that my vehicle already comes equipped and built, manufactured that way.
But here's the difference. Here's the difference. I can guarantee you that if somebody took the time and researched what these roadworthy requirements were state by state, they would be different. There'd be similarities, but they'd be different. So for Terex to sell it and say it's roadworthy, they're not guaranteeing you that it's legal in Michigan. They can't. Stop. I'm not done with my argument. That's where the registration process comes from. The individual states saying, yeah, Crucell, we think your Terex is legal on Michigan roads. That's the whole part of the process that changes from just any old thing that they decide they want to ticket somebody because they had it on the roadway. They could claim it's an ORV. No, they can't because it's registered. My F-150, your F-150. It's registered with the state of Michigan as a motor vehicle, i.e. legal to be on the roads. That's what kills your overly broad argument, is because there's a process by which it is no longer an ORV. It's now roadworthy because the state of Michigan is registered as such.
But again, the state of Michigan is arbitrarily trying to convert everyone's right to travel by saying
that's a different argument.
Yeah,
that's a different argument.
I get where you're trying to go with this. I understand that. But again, you look at this definition, and no one said anything again. It all goes back to I was not cited for no registration. I was not cited for insurance. None of that stuff was even brought up. It was strictly the ORV that they're trying to stick to. And again, by going off this definition, that can be any single vehicle in the world. Anything that they want is capable of going off road.
Well, but here's my ruling. Here's my ruling. Because there's a process to register vehicles, whether or not they're ORVs, F-150s, whatever they are, because there's a process in the state of Michigan is to register them as roadworthy, I don't think that's overly broad language. Because I think you can't read everything in a vacuum. So my ruling is, on that motion, I deny your motion that it's overly broad. I don't believe it is. But I still have problems with the way the whole thing went down. I'm trying to figure out how to deal with that because, and I think I've told you this from the beginning. I get it. Matter of fact, I think the first day you were here, I get it.
So here it is. Probably the biggest matchup of the tournament. Judge Simpson, the #1 seed, Judge Middleton, the 4th seed. This is going to be interesting. I know.
Kirk Jensen.
The problem is, like, I mean, maybe the thing is, I feel like if I put Judge Middleton on the opposite side, this would have been the championship, and it would have been like a foregone conclusion. So that's why I put them in the same half, because I knew that these two would probably make it to the Final Four at minimum. So you're gonna have to dig deep, think about who do you think is the best? Who would you give the edge to? And we're gonna start in 3, 2, 1. Oh, wait, no. Hold on. 3, 2, 1, go.
Here who's unrepresented. Mr. Jensen, would you come up and have a seat? Josh, you kind of inherited this. Mr. Jensen was originally charged with traffic violations. The matter was set for a jury trial for August 16th, I believe it was. We had summoned jurors and we were ready to proceed. Earlier that week, I believe August 14th, Mr. Marvin filed a felony complaint based on the same set of facts. So the matter was set for a pre-exam conference. Mr. Jensen has made every court hearing, but he did express that he wants to represent himself. I offered to appoint counsel at each stage of the misdemeanor proceedings, and again in this case, but he declined. So, Mr. Jensen, you still wish to represent yourself in this matter?
I wish to have this case completely dismissed.
Well, that wasn't one of the choices.
Well, everybody feels that way. Everybody else who wants their case dismissed, raise your right hand. Yeah, that's unanimous. So that's not up to me. But the question is, I'm willing to appoint counsel for you, but you've represented to me at each stage you wish to represent yourself.
I do not wish to have any counsel.
All right. Well, then let's talk about where we are. Where's the complaint? The complaint alleges that on or about April 6th in Lockport Township, that you did obstruct justice by preferring a counterfeit U.S. passport and counterfeit international driver's license at the time of a lawful traffic stop, an attempt to avoid criminal liability for driving without a license. The way that is charged, it is a felony punishable by up to 5 years imprisonment and a fine of up to $10,000. The second count is possession of a reproduced, altered, counterfeit, or forged chauffeur's license, operator's or chauffeur's license. That's a misdemeanor punishable by up to a year in jail and a fine of up to $2,000. Count 3 alleges that you had no valid operator's license, plain old no ops. You're also charged with a civil infraction of no proof of insurance.
And I object to those. I object to that being labeled as counterfeit on all of those documents.
All right.
That's fine.
Mr. O'Bear, do you have any instructions here or a plea offer? Or?
So the offer would be if the defendant wanted to plead to count 3, operating with no license, it's the 90-day misdemeanor. We would recommend fines and costs.
I object to that, and I will not consent to that either.
Okay.
All right, let me unpack that a little bit. All right, you're charged with a felony And you're charged with possession of a false or forged counterfeit license. You're also charged with no proof of insurance. Prosecutor would dismiss all of those charges if you plead to no valid operator's license.
Wow.
With a fine and cost. You may be the first person in my 21-year career that objects to having all the felony charges dismissed for a plea to a $200 fine.
Jesus.
Nonetheless, you object.
Okay.
I object to the fact that it's been labeled as counterfeit.
All right, well, they're just willing to dismiss that charge. The allegation in count 3 is that you are operating a vehicle on a public roadway without having a valid license, sometimes called no ops or no valid operator's license. It's under 257301 of the Michigan Traffic Code. It's punishable by up to 90 days in jail and a fine of up to $100. It carries 2 points and it goes on your driving record. If you plead guilty to that charge, I'm going to fine you $225. I'm going to give you time to pay it, and the matter will be done. If you don't wish to plead to that, we're going to have a preliminary examination next Wednesday, where the prosecutor will attempt to bind you over to circuit court on felony charges and continue the matter for a felony conviction with a potential prison sentence. So his offer is to just be done with all of it for a plea to no valid operators. I frankly was kind of surprised by the generous offer, but that's what it is. So our options are to plead to having no valid operator's license. You can even plead no contest. You can plead no contest. You don't admit what happened, but you also don't deny what happened. And you allow or accept that a conviction will enter. You and I have a fundamental disagreement about what it means to operate a vehicle or what it means to travel. But if you want this matter to be over with, you can enter a no contest plea to no valid operator's license. If you want to reap the whirlwind, we can have a preliminary examination next Tuesday
he wants to reap it, all right.
Regarding the matter. What would you like to do, Mr. Jensen?
I don't accept any of that.
All right, the matter will be set for prelim.
And just to make it clear, this will be the third time that a charge of no operator's license has been levied against me, and I'm standing against it because those documents are valid, and I object to them being labeled as counterfeit.
Find out next week. So that will be Tuesday, September 5th at 1 p.m. Prelim. All right, your bond is continued. You're free to go.
And just a reminder of the civil case that is ongoing, and those who are named in that, yourself and Mr. Marvin as well.
Which civil case is that?
Civil case, the notices, and all the recusals and everything that's been filed into this case that I've been filing in. Just to make note of that.
With
it
who?
is, on the record.
Well, let's take a look. Oh, you filed a August 28th, which is yesterday. I got this. I didn't see it.
Being
objection
sued.
to the report recommendation in the matter of civil case. You filed this in federal court?
This was done in a federal court, it has a federal case number on it, and all the defendants are listed.
Okay.
All right.
Along with the notice.
Oh, it's great pleadings. It cites Abraham and the Book of Nations and a bunch of other jabberwocky. But it has been filed in the federal court. All right, that's all a matter of record. It's in the file. And you've even got Hebrew letters in here.
Wow.
Okay, I'll see you next.
Wait, is he another member of the Kingdom of Israel?
Tuesday at 1 o'clock. Yes? Yes?
I'm Mr. Jensen's transportation.
Yes.
On the 5th, my wife has chemo, and I have to take her to that. Is there a way that we can put it off to the following week? If that's all right with Mr. Jensen?
That would dump the matter.
No. Yeah, no, Chris, he's citing the prophet Abraham. Oh. We're gonna borrow Van Balian.
You're also charged with speeding. I'm assuming you're gonna plead not guilty to both of those?
No, of course not. I'm innocent, and my name is not Mr. Purdue, so I would appreciate if you didn't call me Mr. Purdue.
Let me tell you this. Stop. Yeah, you're from some alternate universe where you don't have to obey the laws.
No, you don't respect the law, sir.
Stop. If you drive again here in St. Joe County, I'm going to set your butt at $10,000.
They continue to pull me over, and they won't leave me alone.
Well, stop driving. At least stay
I
out
don't
of.
drive, I travel.
All right, traveling is one thing, driving is another. You can travel all you want. All right, but let me make this
That's
clear.
what I'm doing, and they won't let me travel. They won't let me travel on my own land. And you're violating the law, and you know it.
Well, one of us is. I'm just telling you, if you continue to keep driving on some
I
cockamamie
don't
thing, you're behind the wheel of a car. Give me this BS about traveling versus driving. I'm just telling you right now, you heard it here. If you drive again in St. Joseph County and you get another ticket, I'm going to set a very high bond. You can sit in jail for 28 days until we sort this out.
Well, they are back for another bout. But Mr. Bay is late for his trial. But even worse than that, he turns up late with 3 bench warrants for failing to appear for his last pre-trial hearing 3 weeks ago, and totally unprepared to represent himself. Judge Middleton is not happy.
Deborah Davis is here from the prosecutor's office.
Debbie!
Samuel R. Perdue, who also is known as Samir Morrow Bay, is here today. He has 3 separate driving suspended charges that were scheduled for jury trial. File 213ST alleges driving suspended second offense on January 31st, 2021 here in St. Joseph County. File 202073 alleges driving suspended on September 17th here in St. Joseph County. I think there may be a speeding charge with that.
Oh, hold on.
File 202653 also charges driving suspended second offense and forgery and speeding. All of those matters were scheduled for jury trial today, November 10th. Mr. Morrow Bay wishes to represent himself on these matters. He has a perspective on the Michigan Motor Vehicle Code that disagrees with the state's version of it, but
This guy can't even turn up for his own pre-trial, and he's late for this trial. So I don't think any of his debunked legal theories will be getting any kind of airing today. Just a hunch.
he didn't want an attorney.
Maybe not.
And didn't wish to have representation. He wanted to represent himself in all of these matters. So we treated him like it. We set the matter for a final pretrial to prepare for jury trial. And he didn't show up. So there are presently 3 arrest warrants for Mr. Morrow Bay's arrest for failing to appear for duly scheduled last pretrials about 3 weeks ago. We don't show up on the morning of trial with a basket full of papers and inconvenience 30 to 50 jurors who have to come in and hear your case and several witnesses without preparing for it. So we scheduled a pretrial conference and you didn't show up. So I called off the jurors for today, and the prosecutor has called off all the witnesses. And there are currently 3 separate warrants for your arrest for failing to appear. But you're here now.
Judge Middleton has given this guy so many chances over the last few months and has treated him really well, but we all saw this coming a mile off with how disrespectful he was in previous hearings. Judge Middleton is a fair judge, but this guy is pushing his luck.
I think I was unaware.
We sent that to the address that you gave us. And if you're representing yourself, you need to act like you're representing yourself. We sent you duly notice to your Sage Street address in Kalamazoo. The same notice you got for this.
I don't live there anymore, and but I can't represent myself. I am myself.
Oh my
All
God.
right, well, I'm not clairvoyant. I don't know that you moved. So, Mr. McNair, you're driving me crazy. I'm going to put you in the waiting room. You're walking all over the place and flashing the screen and giving me vertigo, and you're sideways and upside down. So I'll be with you in a bit. Don't go away. Yes, that's your position. Then you're not doing a very good job of it, because you didn't tell me where you lived. You didn't show up for a pretrial while we prepare for this. And now you come rolling in with a hat on the morning that your 30 or 40 jurors are supposed to be here. That's not a very good way to do business.
It's my religious interest. I'm a Moorish American national.
Yes, I recall.
Of course.
Well, that looks like a plain old woolly hat to me, but what do I know? Oh, and is that...
Yeah, I thought it was a beanie.
Your fake Moorish driver's license there, I can see, because that won't help you now or in the future, because it's not a state-issued driver's license.
All right.
Jurisdiction to begin with.
Ms. Davis is here on behalf of the prosecutor's office. Ms. Davis, do you have any thought on this?
Your Honor,
I would ask that he be held in contempt for failing to appear at the last pretrial. I would also ask that an order enter regarding discovery if all of these items that he's holding on to are intended to be used as exhibits at the trial. I would like to have copies of those so that we can be prepared. Also, I'd like to have our motion for joinder of the cases heard so we can settle that matter prior to choosing the jury and having another date set.
Right in the middle of my busy arraignment morning when I have 14 people waiting to be arraigned, that probably work out too good. But it's all on him. He didn't show up. He also got notice of your motion. Mr. Morrow Bay, do you have documents that you were going to present as part of your defense?
I mean, I mailed in documents and I never got a response.
Well, a real lawyer would know to follow up on stuff like that to make sure that you are ready for your trial. But you can't even be bothered to turn up for your hearings, so expect what's coming to you, I guess.
Well, do you have some you wish to present?
Well, I mailed in an affidavit to you more than once, and this is also my legal notice for my lawful name change, because I put it on the record that I'm a Moorish American national and I'm not or a U.S. citizen. Excuse me.
Okay.
I'm a man of the land. I'm native to the land.
Uh-huh.
So a lot of these rules that the state of Michigan is creating is not applicable to me, unfortunately. And I was trying to be respectful to the court and let the court know since the beginning in a respectful manner.
Uh-huh.
I guess that's a no then. You don't have anything to present. What a surprise. Right. And it looks like Judge Middleton has heard enough.
Yep.
And I have lots of documentation to prove it.
Here we go.
I want you to take Mr. Perdue into custody. We're going to execute the 3 bench warrants that are currently out for his arrest for contempt. We'll take him to jail and we'll make an arrangement later to discuss it.
Arresting me right now?
Yeah.
Do it now. Thank you. Mr. Perdue, you're going to jail, St. Joe County Jail here in St. Joe County, and I'm going to hold on to you in lieu of 3 $1,000 bonds until we can review your contempt and the other things we need to deal with. But if you're going to represent yourself, you need to do it right. You need to show up when you're supposed to show up. You need to follow the rules of evidence and procedure. You don't just come in and say, I'm my own country, I'm going to do what I want. So you're going to jail.
I was unaware.
Bond is $3,000 per file, and I will talk with you later. So right now you're going to the St. Joe County Jail. All right, we'll deal with him, Deborah, when we have more time. But he's clearly in contempt. And he is his own person, so he isn't representing himself. He is himself. We'll see if we can sort that out.
Play stupid games, win stupid prizes, I guess. This arrest has actually been on the cards for the last 6 months or so. Judge Middleton did warn him numerous times that this would happen, but at least he's off the road. Well, for now at least.
Mr. Morrow Bay, this is Judge Middleton. Can you? I'll call you by your
we're back.
Preferred name, Mr. Morrow
Part
Bay.
2.
This is Judge Middleton. Can you hear me?
Oh, yes, I can.
All right, we're waiting just a bit for the prosecutor to log in.
Understood.
He was with us just a bit ago. He should be right back.
Sweet.
Mr. Perdue, we are live, even though we're not doing anything here. We're live on YouTube and live on the Zoom platform. As soon as Casey Johnson from prosecutor comes in, we'll conduct our business.
That's not my name.
I know you're known to the Secretary of State by your birth name, but you prefer to be known as Samir Siraj Morrow Bay. And
I'm a national of the land.
I understand.
My nationality. But I thought, did you take an oath to this?
Did
to
I?
uphold the Constitution? Yeah, to uphold the Constitution.
Oh, yes.
And the treaties.
I don't know about treaties. Those are federal. This is state law.
I know. This is, I shouldn't even be here. I should be somewhere federal. I should be in a federal courtroom, and you still haven't provided any delegation of authority order.
Well, wait a minute till the prosecutor gets here, and you can go through. You've said this stuff on each previous case.
I know, and I'm still waiting for my delegation of authority order. I'm still waiting. I never got it in the mail. That's Article 3, Section 2. You took an oath to this. You know it.
Is he in his car, or is he actively driving in the middle of this hearing?
I shouldn't be here.
You could fix that. You could stop driving a damn car, and then
Oh my God, he is.
And you wouldn't have to deal with me, and I wouldn't have to deal with you. which would
But a
make both of
driver,
us.
but isn't driving a commercial terminology?
No.
No.
It's
In
not.
your universe, maybe it is, but in this one, it's
But
covered
according-
by Michigan Motor Vehicle Code.
So what about Black's Law Dictionary?
Well, as far
Drink.
as I know, that doesn't control Michigan traffic legislation.
And as far as I know, you can't make up rules to
He's
undermine the
not.
Constitution. And no matter what rules or codes you make up, it doesn't supersede the law.
Here comes Mr. Johnson. I don't disagree with that. One of us keeps making up rules, but I don't think it's me.
I mean, I'm sure it is.
All right, well, let me call the case. This is file 21213ST. The actual title on the ticket is People versus Samuel Rufus Perdue. The defendant is here. He prefers to be known as Samir Siraj Maro Bey. I don't think he ever lawfully changed his name, but he goes by that name, and he has every time he's been here. He's charged once again with driving suspended second offense. It's alleged that on or about January 31st, he was operating a vehicle here in St. Joseph County while his license was suspended. He also got a ticket for speeding, so he tends to go too fast, always doesn't have insurance, and he doesn't have a license. He has two previous cases already pending. File 202073 is a driving suspended charge from September 17th. He liked that one so much, he got another one on November 25th. I think one or both of those cases he was speeding. That's file 2026653. Mr. Morrow Bay has a different view of the law. He wants to represent himself, which I've allowed, and we had agreed to set those two earlier cases for jury trial. As we discussed earlier, sir, I can't do a jury.
Represent myself.
I present myself.
I'm sorry, I can't represent myself. I am who I am.
I am myself.
All right, but you don't wish to have a lawyer, is that correct?
Oh, no, I don't need one.
All right. Well, now you have your third driving suspended charge, and I told you the last time, if you did another one of these, I was going to set a bond, but I'm not going to. Let me tell you this right now.
I'm a traveler, not a driver, for the record.
We're all
For the record.
travelers in this universe. At any rate, you haven't been convicted of anything. You've been accused 3 times, but you do not have lawful authority to drive in Michigan. If you drive again in St. Joe County, I'm going to set a bond, and you'll either post it or sit in jail while we await the ability to try your case. I can only leave you in jail for 28 days. But am I understanding, once again, sir, you wish to have a jury trial in this matter?
For my national peers.
No, you're not going to have
a land.
You're not going to have a trial of all other batshit Moors.
A long time ago, and it's never been proven, and I'm still waiting.
All right. Yep. I had that discussion with a guy that was in jail once. I said, well, you're in jail. I guess you're in my jurisdiction. Let me tell you this. My jurisdiction is St. Joe County. And stop.
I forgot how good lines Middleton had back in the day.
I'm driving in it.
I don't drive. I'm a traveler by law. And I've already sent you paperwork and you never responded.
Well, because I'm not required to respond to it. You've got a skewed view of things. If this was this easy, everybody would declare themselves their own country and everybody could do whatever they wanted to. So the rules only apply to you.
No.
The rest of us suckers are stuck complying with the law. So let's just figure out who the witnesses are, and we'll also set this for a jury. Casey, who have you got for witnesses?
I'm just second judge. I'm sorry. 22. I had his other files open.
Only here special appearance, only because I have to. Because if I don't be here, you're going to send your criminals to come get me if I'm not here. So I'm only here.
Legal fiction. Take me the 7 months.
Well, and you're sitting in the driver's seat of your car. Now, I'm letting you wear your headgear because I think it's part of your beliefs. So I'm not going to push it. But you're sitting in the damn driver's seat. What's the witnesses?
Jesse Raymond, Your Honor. That's it.
Oh, the police, the so-called police officer who pulled me over.
So-called. And a certified driving record.
Isn't that a conflict of interest right there?
Why would it be?
Don't he work for the court?
He doesn't work for the court. The court's in the judicial branch. He's in the executive branch. Plus, you keep driving too fast. So you're a traveler. You get to travel whatever speed you feel like. You don't have to have insurance, and you can do what you want. All right. Well, anyway, I'm just gonna set this on the jury list with the other 2 cases. And let me say this again: if you drive again and you get another citation, I'm gonna set a $1,000 cash bond, and you can sit in jail. So my strong advice is stay out of St. Joseph County.
So you do
Don't
realize
drive. You're already driving there, so I'm gonna mute your microphone and I'll
no
set
state
this
shepherd.
for a jury trial on a date to be determined.
He's out.
All right, that completes
So
that.
no,
Right?
convert a liberty
he's
into a
back.
privilege, license it, and attach a fee to it, right?
Uh-huh.
You do know that, right?
I don't make the law, I just try to apply it. All right, we'll.
He almost said enforce it, which is not what he does.
Your statutes and your codes are not the law.
That's an argument that has no end. We could, if we live to be 112, we could continue to have this argument. He wants a
Anarchy Television, who's the victim in this case? Your mom. That's the
jury
victim.
trial. He's entitled to have one, and we'll get there when we can get there. All right. Mr. Kaufman, I'll be with you in just a moment.
I think that's the end of that one. I think that's good. All right. It's the matchup is tightening up a little bit, but we're gonna go to Judge Simpson.
It certainly cannot be neutral and detached when Paul says. That was an absolute falsehood. No, you lied to me. Okay, if I may, Judge, very briefly.
We got it. Court does call the case to be Wills, State of Michigan versus Darren Wills.
Oh, this is another. I don't think I've seen this one. This is another lawyer who accuses Simpson of bias. I remember seeing the last time that didn't work out for that other guy.
Edward Martell, P85051. On behalf of Darren Dwayne Wilson, sir, please stand.
Oh, he is going full on. Oh, with the bow tie and everything.
Your full complete name for the record.
Darren Dwayne Wilson. Thank you.
Your Honor, today's the date and time scheduled for a political exam. I believe that Mr. Martell would like to start us off by motioning for Your Honor to accuse himself of this case.
Judge, if I may, very briefly.
Go ahead.
Thank you, Judge. And certainly, Judge, I got much respect for this honorable court. We've been before this court a number of times. Judge, but the court rule is clear, Judge, that a examination must be conducted by a neutral and detached magistrate, Judge. In this particular case, and just for a little bit of context for Your Honor, this is a case where there's already a co-defendant, where an examination has been held, where the testimony has been taken, where the victim or complainant absolutely identifies a mixed race ethnicity, light-skinned male, certainly not my client who's dark brown skin with barrel rolls. Judge, notwithstanding saying, Your Honor did hit the.
Okay, first of all, I don't know why he brought that up.
Sole basis that the people intend to introduce quote unquote identity is through the search warrants and the subsequent evidence that was purportedly obtained thereafter, Judge. I say that all to say that, Judge.
I don't know what case you're talking about. Who's
like, where the hell are we right now?
Co-defendant.
You didn't preside over that. I could make the argument a lot more.
I did not preside over it?
No. So the argument that the counsel did.
Then what am I doing here?
Well, then I'll let him finish, because I don't know. He did not even begin to ring a bell with me.
But if I can just streamline it, Judge. In brief, Your Honor was presented ex parte with 2 search warrants in this particular case. Ultimately, these 2 search warrants, there was information heard, there was a search warrant, there was probable cause found, there was search warrant signed. Judge, we now come before you for a separate analysis of whether there's probable cause in this case, but Your Honor.
What do you mean by ex parte search warrants? Oftentimes, actually, in a lot of times, search warrants are done ex parte. They're usually done by a prosecutor. What?
Your Honor, pursuant to People Be Real, which is 391-124, Judge. it certainly cannot be neutral and detached when Your Honor respectfully has already found probable cause in this case, and specifically the case law says.
Whoa. How the hell do you jump to that conclusion? Because the probable cause that's determined from a search warrant is based upon that evidence that is presented to me in the form of an affidavit on that search warrant.
Yes.
That's going to have no bearing whatsoever on what testimony I hear or don't hear in this case. So I don't even know how you get to that conclusion. But I'll let you continue because I think it's a... Go ahead.
Thank you, Doug.
He's like gonna say, I think it's a fucking stupid one, or he's about to say, like, I think it's a farce. I think it's the latter.
And Judge, just certainly to preserve the record, certainly I don't want to come back on a quash or an appeal or even a remand, Judge, but the case law is clear. It says if the defendant requests a magistrate other than the magistrate who has already heard ex parte witnesses, such as the request should not be or should be regarded as reasonable and reasonable efforts exerted towards compliance, Judge.
What ex parte witnesses did I hear from?
Judge, Your Honor signed both of the search warrants in this particular matter, certainly testified.
But that says I've heard from witnesses. I've not heard from any witnesses.
Judge, so if it's your position.
Does that case clearly apply to search warrants?
Judge, it's not limited to search warrants.
But that isn't what I asked you, Mr. Martel.
Yes, Judge.
Is that applicable? I could certainly see a circumstance where I would have heard, like what you started out with, which doesn't seem to be true, that I heard something and then there would be a request that I not hear it because I've heard the witnesses or testimony. And so in that circumstance, there would be a much different analysis. But now you're trying to cite a case, apply it to something that I don't think that applies to. Just by the very words that you said. And certainly you show me that it says that a judge that has, or a magistrate that has signed a search warrant should not then hear the preliminary examination where they made a finding.
Right.
Judge, specifically this relates to an arrest warrant, not a search warrant.
Okay.
However, if it's the position of the court that Your Honor has heard no testimony, sworn testimony or otherwise, then I guess our request would be moot. But
I have read, so that we're clear, because you're playing fast and loose with words.
Yep.
So that is clear. I would have read the search warrant. I don't recall receiving any testimony at all regarding that search warrant because I typically don't. I make a determination if there's probable cause contained within the four corners of that document, swear the individual.
Four corners rule, drink.
In, sign off on the search warrant. It's really as simple as that. So if you show me a case, Mr. Martel, that says under those circumstances, the court shouldn't hear it, then show me the case. Otherwise, you're wasting my time.
Judge, so acknowledged, I would say that Burrell is applicable. And I would also humbly submit, Judge, as the position of the court, that anything outside the four corners of the exam transcript has been analyzed or sworn to, then it would certainly fall.
Then you're going to need to file a motion. So I can, if it doesn't bear out, I can find it frivolous and I'm going to adjourn this and then I can sanction. You need to file a written motion. How long is that going to take you?
Judge,
how long is that going to take you?
Judge, certainly.
How long is that going to take you? If you cannot answer that question, then I will take a recess. I will give you time to think about that. And then I will come back and I need your time frame for how soon you can file the motion. In fact, why don't we just do that?
We're prepared to proceed.
Why don't we just do that? You can take him back. Court's going to stand in recess.
All right.
10 minutes later.
County in Washington State of Michigan is now back in session. The Honorable Judge Simpson preside.
You may be seated. Bring him back out. Court recalls case of the people versus Darren Wilson.
And good afternoon once again, Your Honor. Good afternoon to your fine staff. May it please the most honorable court. Edward Martell, P 85051, on behalf of Darren Dwayne Wilson. State your name once again for the record.
Have a seat. So, Mr. Martell, you know, I'm a bit concerned. I just take what people give me.
Okay.
But I'm just going to say this. You lied to me at the very beginning of your argument.
Oh no. Oh no. Is this really going to be a full-on crash out?
I went back, had my staff go back. You said that I held a preliminary examination on the co-defendant. I couldn't recall it, but it's not true. That was an absolute falsehood and misrepresentation to this court. Ms. Hughes then points that out, but I'm still not sure. On the break, I go back, have my staff look it up, which was some doing, but if the case that you're referring to as a co-defendant is Christopher Harrison, that case number for reference is 24F22251, our case number. That is not the circuit court case number. I didn't handle that exam. Judge Barr handled that exam. So your initial argument regarding refusal started with and I hate using the word, but it's true. It started with a lie. Then, Mr. Martell, you continued with your lie regarding the import of the case of People versus Burrell.
So I think I think it's poignant that Simpson is saying a lie, because he could say you're mistaken, or you were grossly mistaken, but he's saying you lied. You made it. You intentionally told me something that you knew was not true.
Which you cite one portion of it about a magistrate who takes testimony and does that. And that's why I went through exactly what this court does regarding search warrants. And then you cite a portion of that, and I think intentionally skipped over the first part of that paragraph.
Oh no! Oh, he pulled a sovereign citizen. You intentionally skipped over the first part of that paragraph to mislead this court.
To mislead this court. And I'll tell you what it says. It says, whereas here, an affidavit presented to a magistrate was in conclusory form, which I'm sure those search warrants were, and did not state any of the underlying or operative fact, and no witnesses were examined, which they weren't. We can perceive no prejudice to the accused in having the magistrate who issued the arrest warrant, which is different, preside at a preliminary examination.
If I may.
If I may.
If it's not going to be a lie, go for it. No, you lied to me.
Okay, if I may, Judge, very briefly, I think the record.
Oh no. Oh, okay. He's like, you can tell he's fidgeting in his seat because he's pissed. He's actually really pissed. Like he was doing that. Oh yeah, he's mad. He's mad.
Will reflected when I cited or spoke about a preliminary examination. I didn't speak directly as to this court having held it, but it having been previously held. I was not present at that particular examination. However, Judge, certainly I would make no false representations as to who held it or who didn't hold it. I think I just provided that for context.
You want me to play it back?
Judge, I certainly do not.
No.
You want me to play it back?
Judge, I certainly, if Your Honor, some other time wants to, that's fine.
No, if you're going to sit up here and tell me you didn't lie to me, you want me to play it back?
It says the inconsistency is clear. The attorney initially implies Judge Simpson handled the co-defendant's preliminary examination, but now denies making that claim directly, attempting to sidestep the accusation of misrepresentation. He absolutely said that Judge Simpson handled a co-defendant's examination.
Judge, then I stand corrected, Judge, but I certainly intend to make no misrepresentation.
I stand corrected.
Context. The main argument is what it is. And certainly Your Honor is not barred from presiding over this exam. But again, and I've spoken with my client in the basis of just preserving the record and putting forth this argument, certainly mean no disrespect, harassment, or delay to the people. Judge, we're prepared to proceed. If Your Honor intends to deny, that's fine. Again, we're prepared.
I don't know what your motion is, because everything that is presented to me is not it. Ms. Hughes, do people have anything to say regarding this?
Gee, I mean, it depends on what he's accused with, but honestly, I feel bad for the defendant here.
I have quite the record to make regarding the one thing that I absolutely have to say, even though I think this argument is clear and where this situation is headed is clear, but the thing that needs to be abundantly clear, I do have a lot to say about the law, and I do have my own cases to cite, but if Your Honor doesn't need those, I'll set that aside. But the thing that needs to be said is the search warrants that Your Honor reviewed are what led to the pertinent testimony today. They did not include the pertinent testimony that would be heard today. Your Honor signed off on search warrants that include facts that frankly are not being contested. The defense is not contesting that these crimes occur. They are contesting the defendant's identity. The search warrants led to evidence of the defendant's identity. Facts that Your Honor has never heard before, which is where we're about to go. But frankly, the law that
Okay, so now I see so if you don't understand what you're saying, the Simpson is not the state is arguing that Simpson is not colored or is not prejudiced against the defendant because the facts that led to Judge Simpson signed off for the search warrant are not being used in furtherance of proving the state's case that the defendant is identified as the person who committed the criminal act. She said that Judge Simpson has not heard that, and that's what's important.
I'm choosing not, and maybe I just need to. The law is actually clear that a judge who has reviewed and approved a search warrant, even on facts that they will later hear, that is okay. That procedure is okay. And specifically, I turn to People v. Cameron, which is an unpublished case of the Court of Appeals from 2013, and Cameron is Cameron. And in that case, not only did the judge review and approve the search warrant, but that judge went on to be the trial judge, a bench trial judge. And the Court of Appeals said in that case, the issue that went up to the Court of Appeals was the defendant was claiming that his trial attorney was ineffective by not trying to recuse that judge. And the Court of Appeals said, failing to advance a meritless argument or raise a futile objection does not constitute ineffective assistance of counsel. That is what the Court of Appeals said about trying to recuse a judge who has previously reviewed a search warrant. The other case that is specifically on point is a much older case. It's from 1971. It's People v. Pitchford, 3-3 Mish Act 299, 1971. In that case, the defendant actually, at the preliminary exam, wanted to attack the search warrant that the judge approved. And that judge that had approved the search warrant at issue went on to be the preliminary examination judge. Mind you, on appeal, it wasn't that exact issue. It was more of a statutory interpretation issue that went up on appeal. But the Court of Appeals in that case said the statutory interpretation would have led to the same procedure, that the search warrant judge would have become the preliminary exam judge, and then they affirmed, and the case went back down for exam. But in that case, we don't even have a case where the defense is trying to say that, Your Honor, inappropriately approved the search warrant. And we don't have a case where the defendant is even trying to contest any of the facts that were in the search warrant. Sorry, from having nothing to say, I always have a lot.
No, that's fine. Anything else, Mr.
Just
Martel?
very briefly, and I would certainly respect this.
Because I'm going to tell you that, quite frankly, Mr. Martel, one may have to convince me why you have not, only in terms of your misleading of this court, attempted to try to have this judge recuse for the purpose of forum shopping.
Absolutely.
Because, I think so.
Oh,
because
no.
originally I had to step into this case. And I can tell you, you probably weren't necessarily real excited about it. But that's the way that the system works here. And so I think you're continuing on with that. And because there's no other reason, I think, to try to bring this frivolous argument.
Judge, respectfully, I certainly enjoy practicing before Your Honor, and I certainly had no intent to misspeak this court. Or in fact, when the full exam or the transcript thereafter, as far as I don't believe any misrepresentations were made to this honorable court, Judge. I stand firm on my word. At the end of the day, I think there's a basis for our argument to put forth if it's the position of the court that it's not certainly, Your Honor, we will move forward with your denial and we're prepared for it.
I have not ruled. You will hear my ruling loud and clear.
Yes,
but do not presume that I'm going to deny it. Before I stepped off the bench, I asked, and I think properly so, your motion should be in writing. How long will that take you to do? If you won't answer me, then I will set the time frame.
2 weeks, please, and thank you, Judge.
Defendant's motion to recuse would need to be filed by December 10th. Prosecutor will respond by December 20th. I will hear the motion on December 26th. This exam is moved to December 26th, 2024 at 12 noon.
Thank you, Judge.
Just for scheduling.
Yes, go ahead. No, that's fine.
I am not available on December 26th. I am
That's-
the person that will be filing the response. I would love to be the person to litigate it as well.
Understood. Then preliminary examination, since this is not of the people's doing, and the defendant, by raising it as well as before, has waived any time requirements, the preliminary examination as well as hearing on the motion will be January 2nd.
Thank you, Your Honor.
At 12 noon. 12 noon. Thank you. Bond continue.
Bond continues. Man. Woo! All right, well. That was one of Simpson's better moments, I think. So we now are done. And by done, I mean we have a championship matchup. It will be Judge Simpson versus the upset special of Judge Oakley. Will we see a Cinderella story where Oakley will win over the juggernaut and the all-around favorite of Judge Simpson? We'll see. We'll find out. But thank you guys for watching. We're gonna find that we're gonna find out tomorrow. Tomorrow will be the usual time, 7 o'clock p.m. Eastern, and I think this time the voting will be. I'm gonna leave the voting on for an hour. It's gonna be a full hour of voting, so that you guys can go to other. No, don't go to the other live streams. That's rude. No, don't do that. I almost suggested that. Don't do that. Don't do that. I was going to say go to live streams to get people who you want to support your guy to go and vote, but don't do that. No, don't do that. But get other your friends and family to sign on their YouTube accounts, and then they could vote. You can do that. So, all right. You guys have a good night. Thank you so much. Thank you so also for the support that you give me. The likes, the subs. Check out my Discord, hit that like button on your way out, and I will see you guys next time. Take care. Bye-bye. Adios. Serena. Serena, baby. Hi, baby. You're such a cute girl. You're such a cute girl.